All right, it is 9 a.m. Welcome to those guests who are with us today, and I'll call the November 4th meeting of the Board of Supervisors to order. First item is approving the agenda. Is there a motion to approve?
I make a motion.
Dennis made a motion.
I'll second.
Have a motion by Supervisor Kiefer, second by Ferguson for the agenda. Further discussion? Hearing none, those in favor say aye.
Aye.
Aye, motion is carried. Public comment. Is anyone online who'd like to make a public comment? Hearing none, move to item 3, review and action regarding approval of the October 28th and 29th minutes. I noticed one little typo in the minutes of October 29th, and Auditor Carr has already changed that. We just deleted the word Kiefer in the third line of the minutes of October 29th, if you care to read that. She also sent you an update on that.
Yeah, I also saw that too. I was gonna, but it's already taken care of. I'll make a motion to approve the October 29th minutes and the regular minutes from November, excuse me.
October 28th.
October 28th, thank you.
I'll second.
I have a motion by Supervisor Jorgensen, second by Kiefer, to approve the minutes of the October 29th and 28th meetings of the supervisor. Further discussion? Hearing none, those in favor of the motion say aye.
Aye.
Aye, motion is carried. Review action regarding the approval of claims.
I'll make a motion to approve the claims as presented.
I'll second.
We have a motion by Supervisor Jorgensen, seconded by Kiefer, to approve the claims as presented. Further discussion? Chair recognizes Supervisor Kiefer.
Just, Gloria, do we know what the total amount spent with Bolton and Mink is? This is their final statement, correct?
I don't know.
Or not?
I know, because the project. I mean, there's still hearings and stuff to do here.
I thought that there was some comments that this was their last billing, but I could be wrong. I don't have anything else.
Did you get the bill, did Lexi send you the claims for that, what's been paid out of that a month or so ago anyways?
Yeah.
Okay.
So we have a motion and a second. Those in favor of approving the claims, say aye.
Aye.
Aye. Motion is carried. Updates on various boards, commissions, and activities since the last meeting.
I had one meeting and it was Cedar Valley, the transportation, Cedar Valley Transportation. And for whatever reason, the last minute, they decided to Zoom it. So I was at the transportation building where I thought the meeting was gonna be, and finally called and they made me aware it was on Zoom, and it was practically over by the time I did that. So I did follow up with Jacob Page, and their big item of discussion was they need a new floor cleaner of some type that they, I don't know if they polish the floor with it or if it's what it is, but the one that they were using was, it cost more to repair it than what a new one costs, so it seemed, so if that's the case, it seemed pretty obvious to. Other than that, I been in contact with Keith Starr too on the EMS, but that's my extent.
I didn't have any meetings, so I did have some email communication with Keith regarding the 9/11 meeting coming up this week, so.
I didn't have any meetings, but I've been extremely busy. developing, the working plan that I'll be talking about, in agenda item 8. A lot of contacts were made, and I'll just defer until that time to tell you all about it. Item 6. We're on a discussion regarding the countywide wind turbine maps. And Jesse Willardson is here to lead us through these map discussions. He created these maps. Jesse, would you show us the item A, the 1,000-foot setback waivers, which is something that's been requested, so we get an understanding of what that is.
Okay, so yeah, I prepared a map using the 2,500 points we talked about in previous meetings for the occupied buildings, which are almost a vast majority are dwellings. With a few where there were some grain bins that were not dwellings, those are also included. So anything that met the definition of a occupied building was the green dot. And then I guess a point of just clarification is that on this 1,000-foot buffer, that would require a waiver. So, I mean, it does show a lot of open space, but that is, point one is you would have to understand that the property owner would have to be willing to sign a waiver. And then the other issue is that if there's all these other buffers that interfere, it still won't matter if you're willing to sign a waiver because there are just so many other buffers that interfere with that. And so that's probably the main problem, I guess, in my opinion, is that having the waiver is a good idea. It's just that there's so many other restrictive buffers along that lines. Between the city 2 mile, the conservation areas, the 5 mile eagles, it's just overwhelming with all of the other buffers. So, but there is the possibility of the property owner signing a waiver to get to 1,000 feet. Let's see, we may have taken down the current one. We might have to use one of the township ones.
Okay, we'll move. First of all, is there any questions regarding item A, which is that 1,000-foot setback? I know you would ask for that. Are there any questions or comments about that one?
I don't have any questions or comments. The comment I guess I might make is that it gives the rural residents a little bit of say, so if they want to have it closer, they certainly can, you know.
Oh, yeah. I didn't know those maps were even in there. I just know they disappeared from the walls.
If it's any of those, I should know.
Yeah.
Mark,
So the map, is there someone online?
yes.
Yes.
Mark,
Who
this
is
is Kayla.
Pardon me, who are you first of all?
Kayla McGregor.
Yes, Kayla, go ahead.
Would that, so like whenever a landowner signs an easement, because I know that there's some acreages that have signed, easements with wind companies that couldn't have, turbines placed on their property just because their acreage is small. Would that be the waiver that is signed? Does that waiver, or does their easement cover that waiver?
I'm sorry, I can't answer that question.
Okay, I didn't know it was a separate waiver they need, if it's the easement, a different document.
Well, it's my interpretation that the 1,000-foot waiver would allow a non-participating property owner to exceed the current 2,500 feet setback. So it would allow perhaps a acreage owner to agree to have the neighboring property owner have it closer than 2,500 feet. Now, as far as you mentioned something about the acreage owner already signing with the wind turbine company. I'm not sure where you're going with that question, but maybe you could give more detail that way. If you can hear
Sorry,
me,
it's working
Kayla?
my phone. Yep. I just didn't know if the easement was what by signing the easement, if that is signing off on the waiver. I guess that was just my question. For the 1,000 feet, like if I sign the easement, does that
Other conditions?
automatically allow the turbines to use within 1,000 feet if they choose?
It's a little distorted conversation, but
I think I
At
could
least-
clarify if you would like me to. This is John Robbins, the NIACA.
Chair recognizes John Robbins.
So the 1,000-foot, so if there is currently where a property owner could enter into agreement with a particular developer to sign a waiver, and that would be in the form of an easement. If a turbine is proposed to be located within the particular setback requirement, currently that's 2,500 feet in the current draft, but no closer than 1,000 feet. So that's in the form, it's in the form of an agreement, which is an easement essentially. Does that make sense?
Okay, thank you. Yes, that's what I was getting at. Thank you, John.
Yep, you're welcome.
Are there any other questions or comments regarding the 1,000-foot setback waivers? If not, we'll move on to B. With B is setbacks to the ordinance with amendments as currently proposed, and we've seen this one before, but, where is that at, Jesse?
Well, would it be quicker just to go to one that's like a township level?
Well, we're talking countywide.
Okay.
So if we can
I will
just
have
sort
to pull it
through
out
those.
of here. Yep, I
That's
will.
fine.
Things got, I guess they fell off the wall, what can I say? It's 25, and that's a township. That's by design.
That, is this it?
No, that's,
Right.
I'm not sure what. Annual reading operation.
Isn't it the one on the wall here? That the one from the right?
This one.
Oh, that's where, yeah, that is the effect of. There's another one that I had that showed the 2,500 foot buffers, the circles.
Actually, this is the one where
You just wanted, you wanted to discuss that one, my apologies,
Go
I
ahead.
misunderstood, yeah. So this is kind of the end result of all of the setbacks, and the blue areas is what is left, the remaining. That does not factor in the possibility, as Jim might have brought up before, that they could sign a waiver. Again, it would still, the problem is that there are so many other setbacks for everything else that I'm presuming it will open it up a little bit with the waivers, but my prediction would be not by very much, unless, I think the other setbacks need to be looked at. Having the waiver is a good idea. I think it's good. I do think that you need to look at the other setbacks. I do believe that, not to say that you don't wanna have a setback, but I do think you have them too large. Between the Eagle's Nest and the 2 mile for the city. And just the kind of the effect of everything is just kind of too much. I mean, that's just my opinion.
Any questions regarding, comments regarding the setbacks that are currently being proposed? And that is the best effort we can come up with to show you what land is left for development for a wind turbine. Minus the possibility that there could be some waivers from some of the individual landowners.
We do that, we know. Yeah, that's it.
All right,
I have a question.
yeah, go ahead.
A comment. Jesse, you and I talked about, 3 mile setback versus 5 mile on Eagles Nest.
Yes.
I think there's a map of that, isn't there?
That's that's probably the best one right there, where the 5 mile is the light purple, and then the solid purple line is 3 mile. I mean, it helps a little bit going from 5 to 3, but you're still taking out a large chunk of the county.
With eagles.
Yes, the Eagles Nest is a very damaging setback, in my opinion, to this whole thing. Not to say there isn't other things to discuss.
Do you care to offer a suggestion, for Eagle's Nest?
I could give an opinion, but I wouldn't necessarily say it is based on evidence of research. I mean, I haven't done exhaustive research. I might ask for John Robbins' opinion, or even another good resource would be, the conservation director. I apologize, I'm still working on names. I've been at the job 6
Adam
months.
Sears.
Yeah, so, I would say, let's bring Adam into the discussion. But I will tell you that I do think, and I think the repopulation of eagles is great and awesome. I don't wanna be perceived as someone that doesn't like eagles. But, I mean, there is challenges to putting a buffer, or I guess that's the GIS word, but like putting a setback on a living organism that can move around. It's not something I've seen a lot in zoning in the past, at least nothing I've directly had to enforce before. So,
Share with Mrs. Ottercar.
And I would just say, even from that map there, I just had one of our voters in that has an eagle's nest on the corner of his acreage. And asked him when he was in and voted the other day, how the eagle's doing, and he said, nest fell. He said it fell a year or so ago. He said, there's no eagles there anymore.
Whitemer Springs.
No, this one happened to be like hollow.
Okay.
just from an enforcement side, I do think, not even saying whether I think the setback is right or wrong, I do think enforcing that would be extremely difficult. I mean, like she just said, if the eagle's nest falls, I mean, okay, so is it a setback or isn't it?
Even one,
If it's not there, I don't think it would be a setback.
Yeah. It's challenging, that's all I'm saying.
Yeah. Okay, thank you.
The only comment I had, when I discussed it with the, state DNR person who is in charge, they don't map where any eagle's nests are anywhere. That's their job, and they don't do that. So it's really would be up to locals to identify where those are. So that makes it more difficult, in my opinion.
Yeah, I guess they're either there or they're not, but, yeah. Okay,
And sometimes I've been told they return to their former nests at a later date. So identifying which ones are active and which ones are not would be another challenge. And any other comment regarding that part of the maps?
I'd offer a couple comments if you don't mind.
Go right ahead, John.
As far as like the 5 mile, 3 mile, setbacks we currently have in play, those are based on a letter written by the DNR. And to my understanding, that's more of a high, so that's like a high level. This is where we're gonna set a blanket review of, you know, wildlife impact, and then they send it down for a more thorough on-site review to the local wildlife biologist. There's a couple different options we could do, you know, because that, I mean, like the 5 mile setback alone, just based on the maps I saw, eliminated almost 2/3 of the entire county just from even being considered for development of a wind turbine. We could these are just thoughts on options you could do. You could have possibly more of a, maybe like a 1/2 mile for Bald Eagle's Nests, just as a base. We already incorporate the conservation department as a part of the conditional use permit review in the current draft, and then get a more thorough recommendation to the Board of Adjustment from there, maybe even in consultation with the DNR to further kind of go with a further review. Additionally, a good example of another alternative approach is like what Lynn County currently has in place. They employ a wildlife impact plan as a part of there, so there's monitoring and stuff involved. There's some overlap with their take permit with US Fish and Wildlife. So those are a couple different options you could consider as we kind of come to whatever we ultimately come to.
Thank you, John. Any further comment? All right, hearing none, we'll move along to map C, which is the one in the corner back there. Jesse, if you'd like to go back there. This map is the current setbacks that are in place under the existing ordinance, not the one that we're working on. This is the one that's in effect today, that the 50 wind turbines that exist in Floyd County were built under. I'm calling this the doomsday map, and for good reason. Because if we have litigation, and if Floyd County loses that litigation, similar to what happened in Worth County, we go back to that map. I realize there's two ifs there, but I want to remind you of our county attorney's opinion, which is in the packet and we'll be reviewing again, which says, I quote, "Unfortunately, from my observations of the actions of the Floyd County Board of Supervisors, it is my legal opinion that Floyd County would very likely have a very similar or identical outcome in potential litigation as Worth County. I strongly recommend that the Board of Supervisors amend the wind ordinance to provide reasonable regulation and avoid the cost of a long-term court battle that the county would most likely lose. The high probable outcome of a loss in court would leave the county vulnerable to inadequate wind regulation." That's why I'm calling that the doomsday map. Because that has an awful lot of white area. Yes, Chair recognizes County Attorney Pritchard.
Yeah, I'm sorry to go back just before we get too far from the wildlife and I guess the eagle discussion. I did just pull up Lynn County's, what they passed in July, off their website, I have a PDF. What they did is they're gonna monitor avian, so all birds, and then all bats. Which is probably a good idea, because bats, kind of a threatened species, I understand. But they go, 2 miles, and so within a 2-mile range of the windmill, they look and they study the deaths, and just kind of monitor the death rate within that 2 miles is what they're saying. And so I thought, John brings that a very good point up, and I found it here, and that's just something I thought I'd throw out there before you get too far away. I'm sorry to back you up a step here, so.
No worries, understood. Now unless there's further comments on eagles, we're talking about the next map, which
If I could follow up with a question, Todd.
certainly,
What organization or what entity monitors these? I'm not familiar with that to know.
I think they put it on the wind development,
Okay,
and it's probably in cooperation with their county conservation.
okay. Thank
That's
you.
what they're doing, and then they take into things like if they have to, they can bring the turbine offline.
Pardon me?
They can bring the turbine offline, or if it goes down to repair, they're looking at that. That's a good time to say, hey,
Okay,
maybe this one's in a bad spot or something like that.
okay.
so Chair recognizes Boyd Campbell.
I was just wondering, Todd, I mean, after this is built and they come in and have the study, is that right?
Well, I think it's an ongoing study.
Ongoing study.
Yeah.
And
And that makes a lot of sense, right? Because eagles move, some nests are active, some nests go inactive, birds, it's changing.
yeah, so if there's a problem with one, what do they do?
I think upgrades or retrofits to existing turbines, I'm paraphrasing, should not result in increased collisions. So the 3-year monitoring timeline will restart after 12 months of discontinued operation. So I think they probably come up with some sort of plan. Maybe they bring it offline. Who knows what? I don't know. But I
That
think
seems kind of high, like, doesn't it? I mean, they're just, after the expense of putting up a turbine and then they're just gonna shut it down. I got a feeling that.
It's definitely.
I don't think that's what happened.
But they, I mean, not that they were late, but like, you know, they turn the windmill off, they pitch it, if it becomes too windy, right? And I don't know if John has anything to add on this,
Did you hear any of that, John?
Yeah, that's a good, I mean, it's a good question. I mean, it's a brand new, ordinance that they implement. I would imagine they'd have to work with US Fish and Wildlife or, the Iowa DNR to come up with solutions on corrective measures. Maybe it's like like if it's like a bald eagle or something, like, for example, they can do what's called a removal permit. So they wait till after the nesting season and then maybe move the nest. So if there's an issue with that in particular, that might be one solution. So there's probably methods to do it without taking the turbine offline permanently. But I would imagine there's going to be different solutions that they come up with a plan for with wildlife professionals.
Can I make a comment?
Chair recognizes Audrey Carr.
I just, Bill Fluer did this for Mid-American Energy. I believe he reported for 8 years that he was tracking the bird loss. He reported that at one of the meetings and that it was, no eagles. Couldn't necessarily confirm that a bird was dead because of a turbine in a field. Could have been something else, but very minimal, nothing substantial, nothing to report at all. You would be a good resource to talk to on that for more information.
Chair recognizes Swati Dandekar.
Thank you very much. My suggestion is, maybe we should just call it Charlie Nichols, Upland County. He's P&Z director, so maybe Jesse, that would be the best thing to do and ask him exactly how we will handle it. And John can do the same thing. So instead of us guessing, we can give it to Boyd what he's looking for after you talk. I'll give you his phone number if I have his phone number and everything. Yeah. Thank you.
Chair recognizes Dean Jaden.
Conversation with Doug Cam, he was part of that bird study for over 5 years. He said he worked with the developers out here on this wind farm we currently have. And he asked him personally, but he said there was nothing out there. He said, and they were even spotting dead birds out there because they wanted to track what the coyote were doing with them and that type of thing, and virtually none.
Chair recognizes Boyd Campbell for the second time.
I have two, okay. In question of that, were there out there eagles' nests lately? I mean, since they've been put up, I wonder if eagles, or birds will avoid that place.
I don't, you'd have to ask.
I mean, as opposed to existing ones.
Yeah.
I mean, if we bring it all down to half a mile, let's say, like I don't know, I mean, eagles are pretty smart. They move out. Was there any eagles around Mid-America's wind turbines? I don't.
I know up at our own personal turbine up there, and of course, that's not near the size. But we have eagles' nests, within, I would say, less than a quarter of a mile of it, and we've never seen one thing happen.
And how
up
big
there.
is that?
That's a 500 megawatt machine, which would be half the size of the ones out here. But it's still got blades. It's got, it's about 200 foot to the top of the tips.
Not 450 or 600.
No,
Okay.
Thank you. Chair recognizes Audrey Carr for the second time.
Like, there is a new eagle's nest just over the viaduct over here. There were 2, and then 1 fell down. And then a third one, has been discovered, but it's not been there very long, and that's within a half mile from the, turbine here in Charles City. In the city limits, or just outside of the city. And there's one across on Highway 14, across from Zoetis, Hendricks. That's even a quarter of a mile from the tower here.
I can give you kind of a real world example, not wind turbines, but of eagle disturbance.
Go ahead.
Yeah, so when I was Saragota County zoning administrator, we were reviewing a crop dusting airstrip. And we discovered there was eagle's nest within about 1,500 feet of the end of that proposed airstrip, is actually repurposing it back to an airstrip. So they had to go through a disturbance review with US Fish and Wildlife, and they still allowed them to operate, but they had to alter their flight path. And prop planes can be quite noisy, so within about 1,200 feet, they would have to veer to a certain direction. So as far as Fish and Wildlife is concerned, they can. I mean, that was pretty close. That was surprising actually to me. So just to give you kind of an idea of how they look at it.
Any final comment on Eagle's Nest before we return to item C under our countywide map? Hearing none, we were at the point where we're taking questions or comments regarding what happens, our current ordinances in effect. I label it the doomsday map because that's what goes into effect if we lose a lawsuit and similar things happen in Worth County. Do you recognize the Floyd Co?
Explain that back to me a little bit. The red dots those are occupied, places. Is that right?
Jesse, you answer that, please.
All right, yeah, so the dots are occupied buildings or dwellings. A very substantial amount of them are dwellings. There may be approximately 50 that are like sites of like grain bins that don't have a dwelling.
Okay, but they're primarily, people are living there.
current.
Yes.
And,
Yes,
and that's what, to make this clear, that's, the 2011 ordinance that we have. Right? I
Yes.
mean, okay. My question is, the lawsuit, doomsday, what goes back to that, there would be further, discussion or whatever going forward from that, because there's no setbacks there, really, right?
Well, those are the setbacks in place. That is based on 115% urban height from those occupied residents and 115% from the road right of way. That's why you see that little area around all the roads. Terry recognizes county attorney person.
So, just, I want everybody to kind of understand, as I've said, and Tom has said, and I think any lawyer would say, we don't know what it's my understanding that Worth is likely to appeal. Worth will tell you, they don't know what's gonna happen on their appeal. They could be successful in part, they could be completely successful, they could lose the whole thing, nobody knows. But what did happen with what the court did order is that in regards to that development for Worthwhile LLC, they are grandfathered to the old ordinance. So, because they were found to be vested. So, if we were to be sued by Invenergy, yes, and Invenergy, okay, then they were found to be vested. And then we had the same result as what they got in Worth County, assuming they found to be vested, then they would be subject to the ordinance in place. If that Worth County decision was our reality. Now, the other companies, I understand there's NextEra and maybe a third potential? Just NextEra. NextEra would not necessarily be subject to that, grandfathered into the old ordinance. But, so just kind of lay that legal groundwork in terms of what's in the realm of possible or likely outcomes here.
Chair recognizes Mr. Groshans, Douglas Groshans.
Maybe a question for Todd here. With Worth County, it's my understanding, you can correct me if I'm wrong on this, but it's my understanding that in Worth County, the problem was they're being vetted. They were permitted and started some work, actual work, and then they tried to do the ordinance to walk it back and say, no, you can't use that now.
They
Is
had,
that correct?
well, they had, I mean, their facts are a little bit different and everything's unique. That's a good point. It's something to always keep in mind. I don't know if they had their permit yet, but they did do a form, not a foundation, but they did lay a form. And I think what I understood that to be is it was kind of a requirement to have that step for tax purposes. But what the court looked at in saying that they were vested was the amount of money they spent, the time and effort, the progress they had made. And that's where I was a little surprised, because they didn't apply for a permit. I would have thought in some of the, there's a Cedar Falls case where they look at that permit. So that's an appealable issue. I think it's a gamble for both sides in front of the appeals court. There's no other way to say it, because I can't predict what the appeals court, Supreme Court will do. But I have opinions about it because I've argued a few cases and I've watched some property cases there. And I would be careful. That's why I urge caution. Because this seems, but it's anybody's guess.
So what is different about us than Butler County and a whole bunch of other counties in Iowa and other states that had the ordinances, the strict ordinances, and they're not being sued, they're not running for cover, worried about lawsuits?
Well, I mean, we have a developer in the room. Right? I mean, they're actively developing and they're like Worth County. They're on that progression, right? And so they're very much, it's very.
But they haven't been permitted yet, though, correct?
To see that they weren't permitted in Worth County either.
So.
And the judge still found that they had a vested interest.
I can add some little clarity on the Worth County case. Just one difference.
Hi, John.
Oh, sorry. One difference with Worth County, I don't know all the particulars and the locations of the turbines. The parties involved could answer that, but Worth County was only partly zoned. They only had zoning in 3 townships of their 12 townships of that county. So they may not have needed to apply for a permit because it wasn't technically zoned or assigned on their zoning map. So that's one difference. And the other difference between these other counties haven't been challenged. That's the big difference.
So I mean, attorneys are always kind of get a bad rap because we can't say anything definitively. Can't. I know definitively at the trial district, at trial, in the district court, the initial first trial, Worth County lost, pretty clear, right? Good judge, well-reasoned decision, she made she'd get an A+, if she was writing a law school exam. But now that's gonna be reviewed more than likely. And what the Supreme Court will do with it when the 7-judge panel in Des Moines looks at it, anybody's guess. Like I said, I have my opinion, and my read of this court is that they will likely go with the developer because they are a pro-business. That's where they're probably gonna go. They're gonna view these as over-restricted. But that's just one opinion. I could be completely wrong. But that's the gamble. That's the gamble Worth County's gonna have to make. They're in the game. It's the gamble I'm trying for us to avoid. Trying to take out the gamble.
Chair recognizes Merlin Schweitzer.
Yes, so is that why this is being pulled on? So they enter to when people can invest more money in the county?
No, we have a moratorium.
Well, they're still signing people up and paying them. So is that gonna make, they're more invested this way, to make it look good on their side?
It could, but I mean, we kind of have a moratorium. They're put on notice with that moratorium that, hey, we're gonna stop, we're pressing the pause button.
But they're all still signing people up, still paying people.
Yeah, I don't know. I mean,
Yes,
and
they
that's,
are. That's what they're doing. They're out spending more money, so they be more invested. So the more invested they are, the judge is gonna look at, they did more invested. So why are we prolonging this thing?
Chair recognizes Lloyd Campbell for the second time. Third time.
Yeah.
The reason I say that is.
I know, you want to put a limit, I understand.
Because usually people, we want to make sure everyone has an opportunity to speak before we give anyone an opportunity for the second or the third time. You are recognized.
And I'm trying to be fair. Todd, you gave me from Worth County, the judges, everything.
The ruling.
Yeah, and the big part of that is substantial investment. And, that's, how that's interpreted. And since the moratorium was put on here, there's been no building, no cement poured, rerod and all that. I mean, to be substantial, that's a big argument right here, don't you think?
Yeah, it's all argument, right?
Oh, yeah.
But I mean, what I'm in the business of as a lawyer is that I'm in the business of mitigating risk for my clients, right? That's a $300 million project in North County. Somebody I talked to is afraid that the county may be on hook for the delay and cause for profits, like the lost profits. 10% of $3 million per year is $30 million. Last I checked, I think our budget's about 14 million. I mean, that's the risk I'm trying to mitigate. Is that we don't have, a judgment where we've got to settle a judgment for millions of dollars. I'll be honest, I mean, Worth County's not my client, but there's payments for MISO subscription that, there's a lot of profits. There's potential for 8-figure liability.
So anybody can move into the county and start something and say, you're holding me up. I mean, like the pipeline, same thing, we're gonna get sued because we held them up. I mean, there's one thing, but there's another to run scared. And I think our site has just about as good a legal challenge as the other site, quite honestly. So, I mean.
What's the next step, Todd?
Excuse me, is there any further comment regarding this portion? If you have a question, you're free to ask it, Dean, but it has to come through me. Chair recognizes Dean Gaten.
What's the next step if landowners get involved in a lawsuit
Okay, yeah.
that already have signed agreements?
I mean, there's potential, right? I mean, and how big of a threat that is, I haven't studied it, but I mean, there would be potential for lost profit, right? I mean, you look at Madison County, they were looking at, I think, a $20 million liability. That's why that supervisor said, it's time to go a different route, with what was going on in Madison County.
All right.
One comment or question for
Certainly.
Jesse. That map that you just, one on the corner that you last started talking about. I know you sent it to me. Could you send it to me again to the top of my email?
Yes.
Thank you.
Yeah, chair recognizes Dean Gaten.
A point to Jesse, you said that was also all included green bin sites and that type of thing. Our current ordinance does not restrict bin sites, that type of thing. It's just housing, basically, or what's the proper word? I'm trying to think.
Dwellings.
Occupied building sites.
You are correct. I did not remove the approximate 50 to 100 points.
So it would be more white than this is.
Slightly different,
Yeah.
but not substantively different. I still think the visual aid still holds true.
Oh, yeah.
To the effect.
But
Well,
just want to
The only
clarify
point might be that it might even open up
more.
a little bit more, but I think from a visual perspective, if you're looking at the map, I really don't think you would notice 22,500 versus 2,400. But I do take your point. Yep, so the current ordinance, tower or turbine height, 115%. So assuming a 450-foot tower, 115% to 517.5 for, and then also from road right.
All right, final comments or further comments regarding this map? All right, hearing none, we'll move on to agenda item 7, which is reviewing the attorney opinions. Actually, Mr. Reveling's opinion was never entered into the public record because the meeting was canceled last time. County Attorney Pritchard's opinion has been noted and written about in newspapers for weeks since it's offered. I will just summarize it in the interest of time, and also let you know in the interest of time, we have to be out of this room by 11 o'clock because Auditor Carr has some election business that we have to be gone. So just kind of keep that in mind. That's still an hour and 14 minutes away, but we have quite a bit to talk about yet. So I think we understand what County Attorney Pritchard's opinion is. Is there any questions regarding that? We could read it again if you like. I read part of it earlier. As far as Mr. Reveling, he sent us a 2-page letter. You can see it. It's part of a public record. I can read it. I would like to just summarize it, and I believe it's an accurate summary. He says it twice in here. I would recommend to the Board of Supervisors to table the reading of the proposed new ordinance scheduled for Tuesday evening, October 29th, to a later time to allow the Board of Supervisors and the county attorney to enter into discussions with Marble Ridge. Later on, he slightly changes that, but it's essentially the same. When he says in the next to the last paragraph, I would recommend the Board of Supervisors table the third reading of the proposed amendment and have the board and/or county attorney enter into negotiations to see whether or not the parties could come to a reasonable solutions that would protect both the landowners and adjoining landowners. If no agreement can be reached, then the Board of Supervisors can decide whether to go further with an amended wind ordinance. I feel I'm representing his recommendation accurately. I don't know if he's online, but if he has any questions regarding that, I'd like to let him, give him the opportunity to comment on it. Again, our own county attorney strongly recommends the Board of Supervisors amend the wind ordinance to provide a reasonable regulation and avoid the cost of long-term court battle. In summary. Any questions at all regarding the opinions of the two attorneys we've on our agenda? Yes, Chair recognizes Supervisor Keeper.
Mr. Ridley's opinion on the worthwhile wind is different than Mr. Pritchard's to some degree. Would you agree with that?
In what regard, Dennis?
Yeah, in his letter, he said, I'll read a couple sentences. The information I received regarding Floyd County is certainly different than the Worth County facts. As I said in my remarks on October 28th, I am very familiar with the case in Madison County, and those facts are completely different. In the Worth County case, there were issues of whether there were vested rights and whether or not the Board of Supervisors acted in bad faith. The facts have not been fully developed, whether or not Floyd County Board of Supervisors have acted in bad faith. So,
Yeah, I mean, there's definitely a difference. I agree with that, between Worth and Floyd. I mean, there's no two situations are the same. There's, like I said, in talking to some Worth County folks, there are things there that I'm glad we didn't do, or didn't handle it that way. I guess if I can just talk a little bit generally, I think Tom gives a good opinion. I think it's rational. You know, my opinion, I've talked to John, sorry to pull John into this, but I don't think that we necessarily want to have a development agreement with one particular company so much as we should have an ordinance that applies equally to all the developers. We don't want to be seen as giving, we run the risk of, you know, favoring one or the other and creating problems that way too. That's kind of conversation John and I kind of had, and I agree. And I don't know if that it comes out from Tom so much as he's saying negotiate. And I don't know if he's saying so much to come up with a development agreement. Maybe, you know, that might be a clarification of asking him, but I do think it would be best if we had one ordinance that basically serves as the rules for all the developers in Floyd County.
Thank you. Any questions, comments regarding the two attorney opinions of the worthwhile win versus Worth County ruling? If not, we'll move on to item 8, which is a discussion regarding establishing a working group to make a recommendation to the Board of Supervisors on Floyd County zoning ordinance amendments for provisions regulating commercial wind energy conversions and battery energy storage systems. First, I'd like to say the motion to table at the last meeting on Tuesday and actually take some time, as Supervisor Jorgensen said, to get a better picture, gather more information, and make consideration. In my opinion, was a game-changing breakthrough. The first step is always the hardest to take because it requires a leap of faith. And I thank you for doing that. The process was awful. It was not normal and customary and took away from the rules that the Board of Supervisors had in place for the entire time that this board has been in place. But I don't want to focus on that. I want to focus on the solution. And so if you'll bear with me, I'm going to propose something. It appears to me that the Board of Supervisors itself, in an open meeting, cannot resolve this issue. Just look at the discussions we've had today. How do you expect someone to resolve an issue that is this contentious in an open meeting with this side over here, this side over here? We're coming to a conclusion. And we need to do this, by the way, not more than 45 days. As a result of that motion, we have until, I believe, December 13th to work on this. And at that time, we're gonna have that third reading of the ordinance. So soon after I woke on Wednesday morning, I started thinking about the solution. And the first person I thought of was, we need a mediator. We need someone from the outside to help bring these two sides together and find a solution. There are 6 qualities essential to a mediator. One is impartiality. That person must be neutral, does not take sides or impose a solution. 2, the person must be an excellent communicator. Listen actively to all parties and understand the needs of each party. 3, a mediator needs to show empathy and understands the emotional aspect of a dispute and provides a supportive environment for parties to express their concerns. 4, negotiator must have respect for all parties and treats everyone with dignity. And five, and six, the negotiator, a mediator must have confidentiality. The working group I'm going to propose is a confidential process that creates a safe and secure environment for all parties to resolve the dispute. The person I'm going to suggest has all these qualities and more. My plan forward, in fact, I'll call it a new way forward, we would agree as a board to hire, in essence, a mediator to negotiate the solution. I first met Louis Laborado when he served as the Chief Justice in the Iowa Supreme Court. I was the ranking member of the House Appropriations Committee. In other words, I was the minority member who had to understand all of the money that he spent, his judicial branch. I met him at a reception following the State of the Judiciary speech. And I worked with him and his staff during that year to find out what their needs were. I have included his bio in the information that you received this day. He served on the Iowa Supreme Court for 20 years, from 1986 to 2006. And since 2006, he's been working as a mediator and an arbitrator. He's a member of an organization. There are 11 mediator arbitrators in the state of Iowa. He's one of them. He has handled in excess of 1,000 mediations since February of 2007. He is qualified and he meets all 6 of those qualities that one needs. Further, as a state representative, I also got deeply involved in a case called Worth County, or I should say Mitchell County Steel Wheels case. A case where Mitchell County arrested a young gentleman named Zimmerman because they had an ordinance in effect. And prior to that, I attended a Mitchell County supervisors meeting and gave the offer to the Mitchell County Board that Justice Laborado would mediate a solution to that situation that they had. Mitchell County Board of Supervisors turned that down. And eventually, a couple of years later, that case went to district court, appellate court, and all the way to the Supreme Court, where Mitchell County lost a unanimous decision. It's also kind of important to note, and I want you to know, the reason that case happened, because Mitchell County has more wind turbines probably than any other county in Iowa. And the reason this arose because Mitchell County had created a tax increment financing district with the increased value from all those wind turbines. And they used that money to pave many, many roads in Mitchell County. And so the reason they had this money was because they had wind turbine development and they built these roads. But instead of taking that advice that I gave them, or the offer from Chief Justice Laborado, they turned it down and lost. I would like to see Louis Laborado be the chair of a group who would convene meetings to develop a compromise solution. That's, I believe, what we're all looking for. I think that's what you have indicated, Supervisor, a compromise. So I started contacting him. I first contacted him, sent him an email late on Wednesday afternoon. On Thursday, he responded to me. Of course, I remember you, Mark. I'm not a friend of Chief Justice. I'm an acquaintance. I haven't spoken to him since 2011. But when I sent an email to him, he responded. And he said, yes, I'd like to tell me more. So we set up a phone call. We talked for a long time. He asked for everything. He asked for the opinions of both attorneys. He asked for the letter from, Invenergy. He asked for the existing resolution 4223 that set up this process. And he read it through it all. One question he had: does this violate the open meeting law? Because I'm proposing to add a member of the board of supervisors to this working group. And so I said, I'll find out. So that afternoon, I called the Iowa Public Information Board and talked with their general counsel, Mr. Alexander Lee. He said, I don't believe so. I see nothing wrong with a group where one member of the board of supervisors attends. It's a non-binding group. Part of it, they'd make a recommendation back to the full board with any compromise they could come to. The board has no obligation to accept it, reject it, but yet it's there. And I think it's a new way forward because I see we're stalemated. And what's gonna happen in 45 days, we haven't done anything. We haven't accomplished a thing and we're right back to where we were. So the next day he talked to the chair of I should say the executive director of the Iowa Public Information Board, Erica Eckley. You might recall she was in this very room and she gave us a tutorial on the Iowa Opens Meeting Law. And Erica Eckley says there's nothing wrong with what you're proposing. Thank you for telling me in case anyone wants to file a complaint against you. But what you're proposing is sound, getting an opinion of other people to come together. So with that, I thought to myself, well, who's going to be on the group? And so I'm proposing a 5-person group. Certainly the second person I think should be there is Mr. John Robbins. John Robbins has been our consultant from Nyakog since the start. We hired him to lead this effort. I'm 100% satisfied with his work. He has answered every question and written every amendment that every supervisor has asked for. And I think he would be a person to be included. Of course, I contacted John last week, and he is governed by his executive director, Myrtle Nelson. And so he talked to Myrtle Nelson if he could be involved and at what cost. And yes, he has told me that he would like to be involved, and he would charge us $200 per meeting to be part of this process. And if it involved an awful lot of work, John, you're on the line, maybe you could discuss that, something like $300 a meeting. I think I'm quoting you correct, is that right?
Yeah, that's correct. Essentially, it's just continuing our existing contract to help with the ordinance process, where we're kind of beyond the regular ordinance process. So we built that in that flexibility. So $200 a meeting for me to be involved without extra prep work. And if there's significant prep work, $300 a meeting. So yes.
Thank you. Just to step back a little bit, since we're talking about fees, Mr. Lapparato charges $250 an hour and $100 for travel. He's also available to do video conferences. And Mr. Lapparato is ready to go to work at any time we ask him. The time is not a concern. He will meet with this group at any time and start to work. The third person I'd like to propose, of course, to be on this is Floyd County Attorney Todd Bridges. Without question, he needs to be able to provide his legal advice to the group. The fourth person is a representative from Invenergy. Either their legal counsel, Samantha Norris, or Isaac Lampa, the person that both these individuals, we've become known and come to know quite well. They come to all our meetings. Let them choose one to represent them. This is the company that's threatening a lawsuit, so we have to bring them to the table. The fifth person certainly is a member of the Board of Supervisors. Who should that be? By the time this would happen, Supervisor Jorgensen is no longer a member of the board. I'm not proposing that I should be that person at all. I am suggesting that the new supervisor, Boyd Campbell, be the person who represents the board on this 5-person committee. They'd meet in private, they'd meet confidentially, they wouldn't disclose outside that meeting what was taking place. And through a series of meetings between now and December 13th, they try to come together to provide a recommendation to the Board of Supervisors. We don't know if it's even possible. But it is, in my opinion, a new way forward and the only thing I can see to break this logjam. Are there any questions? I'm sure there are comments about this. Chair recognizes Supervisor Jorgens.
I think,
Oh, one last thing, excuse me, before I vote. We'd also have the support of mapping from Jesse Willetson. It's obvious how valuable he is to this process because he can, with a few clicks of things, tell us what this new proposal and how that would affect the available building and not be able to build a turret. So he is also would be available to this process. Chair recognizes Supervisor Jordan.
I understand that timing is, we can't sit on our hands, we gotta start moving on this. I think Boyd would be a great asset to that group. Would it need to start after November 13th when he is presumably official Board of Supervisor at that time?
I think that's true.
Okay.
I think
I
the
thought I
canvass
was-
of the votes would occur on the 13th.
Yeah,
And so after that date, anytime, that could be that.
maybe I misunderstood, but I thought you said between now and November 13th. So, and I don't know if Boyd said knowledge of this ahead of time or not, but maybe he needs to acknowledge if he's ready to do that or willing.
Well, perhaps before we do that, I'm kind of interested in what you gentlemen think of the idea.
As far as everybody or Boyd?
So as far as all this concept of this working group, chaired by a gentleman that's beyond reproach. I mean, look at this file.
Yeah, I
1,000 successful mediations is available to do the job. Seems like a person of stature who could bring these people together according to these characteristics that we need.
I saw his bio, pretty impressive. You know, if it's reality, it's probably not a bad choice. Is there others? I don't know. I didn't.
I did look at others. There are 11 people who are either arbitrators and mediators, and understand this is not an arbitration where they come up with a conclusion and this you either buy it or either you take it or you don't. It's not that. There were 11 people on this list that have to be trained in this field, and only 2 of them had the characteristics that they had experience in land use and planning and local government. And the former Chief Justice was one of those. The other individual I also reached out to, a gentleman named Dylan from Iowa City. And his office has not gotten back to me to set an appointment. So that's how we ended up with Mr. Lavarado.
To go back to your 5, when you spoke of Laverato, is that what you?
Yes, Louis Lavarado.
I think it's safe to say that many of the citizens would consider 3 of them probably pro win. I wonder if we shouldn't, consider mixing that group up a little different.
And which three are you referring to?
I think most of the citizens would agree that John Robbins, Todd Pritchard, and an Indian for Energy rep are obviously, in favor of wind. Doesn't mean they don't bring neutral comments to this meeting. I'm just saying what I think you're gonna hear from citizens on.
What do you believe? You've been involved in this yourself. Oftentimes you refer to the citizens, but is that your thought that County Attorney Pritchard is pro-wind and John Robbins, after all your dealings, is pro-wind?
Where are you going with it?
I'm just asking a question.
I know sometimes things get taken out of context after I say them, so.
I know you represent your constituency group, but you are the supervisor.
Right.
Makes decision.
Right.
So is that your belief that County Attorney Pritchard or Mr. Robbins are pro-wind?
I'm gonna say right now, one of them told me they are, so, if they choose to say they are, that's up to them. They're not opposed to it, I'll say that. If they wanna divulge that, they can. You're gonna get that feedback, I think, or the board is.
This is board discussion at this time. Chair recognizes Supervisor Peter.
Do you know if Mr. Alvarado has mediated any other wind issues for?
Mr. Lavaro told me he has no conflict of interest with wind turbines.
But has he mediated any other wind issues with any other counties or entities?
I cannot answer that question, but he told me specifically he has no conflict of interest with doing this. He's negotiated over 1,000 cases since 2007. Wide variety.
But we don't know if any of them will win.
We can find that out. We certainly can. I mean, but does he have a conflict is a bigger question.
No, it's not what I'm asking. I'm just asking if he's done anything in wind.
We'll find that out.
Okay.
Again, think about what a mediator does. They don't impose a solution on anyone. That's the first qualification. They don't take sides. They're neutral. They're the impartial person to bring people together, which is what we really need at this point.
We obviously have people that are outspoken in favor and the same opposition outspoken. Would it make sense to have, one or two of those people I just mentioned from each side, one or two from each side, an equal amount of all of those?
Well, my thought, when I came up with this plan, was clearly that Floyd Campbell was made it clear where his position is right now. And to the point that I would say he has more concerns about locations of wind turbines. And he is the supervisor, that we need to have someone, clearly it's not gonna be me. I don't think it should be Dennis Kiefer either. I'm looking at someone who's going to represent his district for a month and a half in the next 4 years. And so that's why I kind of took Supervisor Jorgensen out of the question.
That's obvious.
The fact is obvious. The two of you control. You control, exercise your ability to control a lot of things. Agendas, meetings, tabling meetings, and you can control this decision. I'm just asking you to respond to my proposal in a way that is a good faith attempt to bring all sides together to mediate.
I still think we need to. One citizen that is obviously in favor and one citizen that is obviously opposed. I'd be happy to end any conversation with the Todd Pritchard. I think, we actually discussed, I think we're in line with Reevely. And, did we not agree that if we came to something like this, that he would be a good one to have involved as well?
Reevely?
Yeah,
Yeah.
I mean, that, spent a lot of time with, Todd and Reevely on the day on the phone and I don't know how big a group we want, but I still think it'd be important to have Reevely along with a pro and an anti-citizen.
So how do we deal with the member of the board of supervisors?
I believe one member of the board, it makes perfect sense to have at least one member of the board of supervisors. I think we discussed that as well.
Yeah, just gonna have two.
Can't have two, if you have two, you gotta have three.
So possibly you'd like to add Mr. Reevely to the group?
I would be in support of that.
And a citizen or just Reevely?
Well, again, how big do we want the group, but, yeah, I'd be in favor of two citizens, one for each side and Reevely. And keep the group as existing.
We're in the discussion stage, no action to be taken at next meeting. Is there someone, you know, we kind of have to think about who that might be and.
We'd have to
Just one
reach
thing
out.
I do want to point out, Mr. Reevely comes at a cost. Mr. Reevely charges us $300 an hour for his services. And I believe he told us he charged us $300 an hour to travel as well. When I asked him at the meeting, how many hours of time did you have, the meeting that he had attended on, he said 2.5 hours plus my travel time, and so I guess that's clarification, but the dollars are adding up.
There's no doubt.
And I'm not opposed to that, just so you know that. Of course, we'd have to have agreements with any number of attorneys that we hire. Agreement of what their services are and for how long. So is it safe to say that on the current board, the two of you are anti-wind and I'm pro-wind?
I think that's a pretty safe statement. I wouldn't say anti-wind, I am in favor of
Well,
wind.
I see, I know you say that, and thank you for for the breakthrough and allowing the negotiation, but also it was the two of you that got us to this point. Of the amendments that have got us to this position, so
Could I make a suggestion?
just a moment, John, please. But that's okay. So then how about if further out, if you choose one, if that's a way forward, all I'm seeking is a way forward. The makeup of this group, we can negotiate that. That's just the first step in showing that we're already in good faith. If you chose an anti-win person,
Myself.
I chose,
No, I ain't saying
Oh,
myself,
you
you want
yourself?
me to choose.
no,
I wasn't saying that. You want me to choose.
you two, you were the two.
Okay, we
And
really,
then, but we kind of have to do that at an open meeting, you know, we're
Right.
kind of into that thing that, you know, we don't really get together and sometimes we come to meetings with already plans, it seems like. So maybe we better discuss that at an open meeting, who that might be. And I suppose I could come up with someone.
I think that'd be fair. I think it would take a little time to find people that are ready to commit to that, because they need to put the time in. And we're not gonna find somebody at this meeting.
Agreed. So are we talking, two individuals from the county plus Attorney Regeling? So how many people do we have now on this committee?
8. You have 5 and I added 3 if that's what the direction we're going.
But we wouldn't be adding 3, we'd be adding 2, wouldn't we?
Reeve Lee, a pro, and a anti.
Okay. I was looking at Floyd's name, but. Okay, I got you.
And I assure you, County Attorney Pritchard is not biased.
I didn't indicate he was, I indicated one of the people were.
Never mind that. Your statement was your statement.
Okay.
Anyway, are we headed towards something that we can get to?
Yeah, I think so.
Could I make a suggestion, please?
We'll bring a name back to the
One
meeting.
moment, John. We're in board discussion. Thank you.
We both do our best to bring a name back to the meeting that is willing and able to participate. I don't know what,
Both pro and con.
both pro and con. In the
Well,
event
you're not gonna pick them both. That wouldn't be fair.
that, I think I could pretty easily.
But you don't get to pick a pro and a con. The majority does have to understand that the minority, in meetings like this, minority, we all have equal rights. And, you know, just because you're the majority, you don't get to decide everything.
County residents.
So one of you two would decide to pick one, I will pick one that I perceive a county resident. And, I can tell you who I'm gonna pick right now,
I'm all ears.
Dean J. County resident, knows this issue, has been involved, he's the chair of the zoning commission, he's been involved in this in good faith since the very start. Would be my choice.
I hope he's agreeable to. I'm not, at that point that I'm going to pick,
Fine,
maybe Dennis will pick.
kinda gotta know if you'd agree, however, to that choice.
And who's gonna pick?
No, I'm telling you, I picked Dean J. Would you agree to that, Dick? Because we're getting to the point where we're expanding the membership, we're all working together. But, you know, if we get down to that point, and you bring me your people, and would you approve this plan if Dean Jayton was the person that I chosen?
I don't know why not? Let's see.
Any issues?
One question I have,
We're good.
it does take time. Supposing, it's a bigger challenge than I expect to find someone in opposition. Then do we just, balance it and leave them both on? I think I can find somebody, yeah, Kiefer might be able to find somebody in that event.
If you were given the, you know, if you had to make a kind of a, just an off the cuff consideration of who that might be, and you're clearly in tune with this anti-wind group, who would you suggest?
Well, many people have been in this room and spoke. Roger Tretton, I don't know if they're on board to this, perhaps Merlin, perhaps Doug, perhaps, Scott Larson or Candy Larson. Perhaps Kathy Carter, she might be, I don't know.
All good. I'm just happy that we're working towards a resolution, so imagine what it's gonna take when this group gets together. We can show a lot by just agreeing to even create it. And so, in the essence of time, because there's only gonna be a little time left where you'll actually be a board member. In fact,
10 days or something.
yes, you would be here until Floyd Campbell's sworn in. But the next meeting of the supervisors isn't really until November 13th.
Their next meeting on the 13th.
How about this? Let's take this into consideration. When both of you wanted Mr. Reveley to be supervisor, we called a special meeting just to hire him. Would you give it enough time if we called a special meeting, say on Thursday? Today's Monday. If we had a special meeting this Thursday, and really the sole purpose of that is to agree to this working group.
Checking.
Maybe the 7th.
It'd have to be a morning.
Got to be a morning meeting,
One agenda item.
pretty much.
Will you have engagement letters?
Pardon?
Will you have engagement letters?
Yes, and then we'd have engagement letters by that time by both, all the attorneys we're talking about, and,
Would Auditor Carr reach out to Reevely? That's the direction we're talking about, or me, or Dennis, or who?
Do you want me to do it? I can.
I'd rather you did. Okay. Yeah, I think, today is the 4th. I would think I could, make some phone calls, or you want me to do it, or you want to?
Well, let's both do it and come up with a couple options.
Bring them to the.
but understand now, you two can't talk together.
No,
And you two, and by the way, you two can't talk to what is called a proxy. In other words, someone who's over here who confers messages back and forth to you, so you avoid talking to each other. So that's really important. So if you want to individually bring back members and then you decide who that is, I'm fine with that.
we might have overlapping.
Mm-hmm.
I think we're making progress.
And that's good.
All right, I think we've kind of come up with a deal.
So we have a special meeting on the 7th.
We're planning to have a special meeting on the 7th to consider who are the members of this working group. And understand they would go to work right away. And under the chair of Louis Bravo.
Well, if we're getting ready to leave this agenda item or not, but we, need to get some words from
Sure, we
Mr.
will.
Campbell.
Yeah, I think we kind of got, agreement with here and,
Okay.
okay. Excellent. Pardon? I don't know what we're doing.
Can I make one quick comment?
Yeah, please, go ahead, John.
This is just in relation to Jim's thoughts on having 2 citizen members. I think that's a great idea. You have a planning and zoning commission that has been involved with this process, and since they make recommendations regarding the zoning ordinance amendment, I think it would make sense. You can take this or leave this. Candy Brandau Larson has been a part of this process the entire time, so she may be a good one to have involved for one viewpoint. And then another member of the, like Dean Jaden, makes sense as well. So that's just a suggestion.
That's fine. They, as I understand it, the 2 supervisors will come up with a recommendation individually, and then they'll decide at the next meeting, and I'm fine with that. So if that's who you end up with, then that's fine.
When I'm soliciting these individuals, they might ask how many meetings. Does anybody, John or anybody, have an idea? Or, you know, would it be 5? Would it be 2? Would it be one-on-one with Lavardo?
Well, I did kind of ask that question of Chief Justice Lavarado, and as many as it takes, but understand, this gentleman is a professional. He is there, he knows ways to bring people together. So they might be rather long meetings, but I don't expect a lot of meetings. Who knows, maybe you can't come together to do anything. That's a possible outcome. I hope not. I hope everyone understands that you're operating in good faith by making this, and you're gonna have to make some major concessions. It's gonna be more than just equals. Because there's a lot to this that we're quite a ways from. So going into it with that was the option. I don't know how many meetings. It's hard for me to say that. You know, it's hard, I think anyone would be hard. Kind of have a deadline. And, we want to find a new way forward. That's my goal.
Can I,
Yes.
I'm just on some of the rules of it, does Lavarado, is he part of the decision making of the situation? Or is he just talking to the other 7 people, saying you guys have to work with the other 7 people, or is he?
He's neutral.
He's neutral.
Yeah, he does not take sides. He doesn't impose a solution. If they can't come to something they agree to, it's not that Judge Lavarado tells you this is the way it's gonna be. No, he's objective. And that's the key to success. And it's also confidential.
Bring that up as well.
And so,
So those people can't come out of the meeting and go talk to Jim or Dennis or you or.
hopefully not. That's to the best of our ability, you know, but that's what makes it a successful negotiations and, so.
Meeting location, probably in this room.
Mr. Lavarado said he could be here, he could participate online, certainly. From time to time, we have some problems with the setup, but, I think it would be best to really get to a face-to-face to get started, obviously, you gotta get to know each other.
Is the expectations, I mean, you've got some attorneys here, is the expectations that Mr. Lavarado is willing to do this at 7 o'clock at night, or is it, you know, just when I contact Mr. Regally, is there a time that you think, I mean, like, if you pick Candy, she works during the day, so are they evening meetings? Is there some criteria to tell Mr. Everly what expectations might be?
You know, not knowing who, I don't know how, I can't say. You know, I'll read you the email that he sent to me. After we cleared the Iowa Public Information Board, had given it their approval to have this. And it was very short. He just said, he's available to meet at any time. I think that's probably pretty important. We're talking about a pretty
Well, like, you know, Todd probably has court cases at certain times that he may not be able to.
We'll figure something out.
yeah, sure, Rick.
I think this is a good step. I think it's a good idea. Hopefully it works out. I think, you know, there's discussion about like, okay, my bias or something. I want people to understand something. I want to be very clear about this. I'm the county's attorney. I'm not gonna take a vote on this ordinance. Okay? It really doesn't matter if I'm pro or anti-wind. All right? What I want is I want an ordinance that is going to protect the county and its citizens, it's gonna meet public safety. And then at the same time, not get us sued and jeopardize Floyd County's liability in some way. Because, you know, there are some real liability potentials here. And so I think, you know, you talk to people who are gonna be on this, what I'm gonna say, and I think the attitude that people should bring to this meeting is there are counties, you know, that's the beautiful thing about Iowa, is there are 99 counties that are all over on wind, right? Some counties have friendly wind ordinances, some counties can be categorized as unfriendly wind ordinances. And some of those counties have ordinances that probably go too far, like Worth County might be an example. But you probably have counties that don't regulate enough, that don't have enough protections involved for people. What my advice is to this group and to future supervisors is to keep us in, you know, if you want to be on one side, you know, you want to be pro or you want to be hard, you know, not pro wind. But keep us in the zone of legally defensible, not creating a liability for the county. Right, because the law, there is a law that should guide your actions. You are charged, you didn't, I had to take an oath, I think all of you, and you'll take an oath to uphold the Constitution and the laws, right? And that's really what I'm trying to advise the county to do. Disagree with, you know, how I interpret the law, and that's fair, but there is a law.
Well, I guess there was really only one person in the room that we're talking about pointing to this that we haven't heard from, Boyd Campbell. At this point, at the end of this, are you going to serve? Do you think this is a new way forward?
I think, we have to move off where we're at. I think it's a good idea. It's not binding. And, I think Alvarado, sounds good, you know, I mean, the man at Supreme Court, right?
20 years.
20 years. And I think the idea of having two attorneys, you know, I always thought if somebody gives you a diagnosis that you have cancer, you want a second opinion. Todd, you said it was a smart thing to have, maybe, you know, readily. And I think that's a good idea. One thing, now, you two and every. I think there might be a problem with too many on this board in a way, you know? Otherwise, I mean, we sit there and we all have our opinions and we need to work through these. We need to look at both sides, that we don't harm both sides, right? So I guess, I definitely, would do this. But my comment is maybe we don't need the extra people that, the people that you come up with, Things aren't binding. I think, that's the one thing I see is maybe too many people, So, but I'm willing and able and, get the deck running.
Thank you.
Potentially have 4 attorneys, not just 2, but 4. So that is one.
Now, there is one other person I want to kind of get the blessing of. There's gonna be another new supervisor replacing me. And who knows what this group will come up with, if it's with something that's done. Doesn't have to be finished when I'm supervisor. We have a date that we need to have 3rd reading. We can continue readings, we can do lots of things. But Auditor Carter, you're gonna be a supervisor effective the reorganization meeting in January. What do you think of this proposal? Do you have any concerns about some of the things in the proposal?
So like Boyd just said, I do have concerns of too many people. This potentially could take several meetings and you've got 8 people to coordinate a time to get together. Good luck with that, I think. That could be very difficult. There's a lot to do. I mean, we're already 5 days off of our 40 days. There's a lot to do in this time period. Love the idea of trying to get someone to pull this together because obviously it's not been successful at meetings to try to do so. I'm looking forward to it. I mean, I'm ready to keep this moving as well, and I wanna see some action here. I think it could be very interesting, whenever this group is done by December 13th, whatever that day is, to come back to a meeting. And you're still gonna have those in opposition to this, and you're still gonna have those in favor of a reasonable ordinance. And so we could still be in that stalemate that you talked about. But if you keep in mind that I'm glad Todd brought up the oath that you take, you are following the Constitution. I think there is, I'm very hopeful there's some common grounds to this.
All right, thank you. Chair recognizes Supervisor Jorgen.
Thank you. I also wondered if we were getting a group too big. I thought there was merit in getting a citizen from each side. After hearing from our presumable new supervisors. I wonder if we put Lori on, if that's what we want to do. And not have our 2 citizens, so to speak. Just throwing it out there since after hearing their comments, I wonder if we be getting too big. Also, question for Todd. I know we need to not negotiate with one energy company. We need to do this for everyone. With Inver Energy on there, does that compromise that idea?
Potentially, I mean, A lot of, I mean, a lot of it's kind of like, you know, size of the group, it kind of depends on everybody's attitude. I mean, they could look at them as they're kind of a bellwether, you know, canary. If it's, you know, maybe what's acceptable to them will be, they'll give you an indication of what's reasonable in the industry to them. You know, so it's a data point. But yeah, but then, of course, you don't want them to steer it for their purposes at the expense of the other.
I respect your opinion, I just wanted to bring that up, and, your comments on, my first part of the comment, keeping the group smaller, or yours.
Well, it's getting bigger. The other comment I was gonna make, NextEra has been pretty quiet on these issues.
It's true, yeah.
Are they just gonna probably be happy with what we agree with Invenergy supposedly, right? Or will there be another lawsuit?
I have no idea. I mean, I think it just, you know, they're gonna play their hand the way that they see. I'm sure they're motivated to develop a project, so they're gonna wanna make sure they're treated fairly. But, yeah, anything beyond that,
So
Pure
what
speculation.
would Invenergy bring to this committee, or this group? I mean, we know what they want. They made that clear.
They made it very clear, every time they've sent us and told us, they're willing to negotiate. That's the point I take away from Invenergy. They gave us a series of things that they would like to start that negotiation at, but they are very clear and on board that they'd like to continue to negotiate, so that's very positive, I believe.
I will add, I think, looking here, there's an attorney who I know from my days in Des Moines as well. His name is Kelly Myers. I think she reached out, she wanted some documents. I think she's actually representing NextEra. That document request that we had, Gloria, last
Oh,
week.
is that what you want?
Yeah, I think she represents NextEra. So they are in the observation deck.
Yes, Chairman, there's other part.
I would say just even in Redley's opinion, he has a suggestion, you work with the developers, and this is an opportunity to work with the developers. with Invenergy. And they're way farther along than NextEra is in the process, and they have more money invested. They provided something to us a few months ago with what they have for dollars invested to this point. I was trying to find it, and I'm not finding it right now, but, so I think they're good to be at the table. They provided a development agreement, and they're willing to work with you from that point. Where can they go? Because that's probably too far, still too far away from where we want to be.
Mark,
Yeah, Chairman, Dean Gates.
just to echo what Boyd said, I agree, you get this committee too big, you're gonna get some dilution, and it's basically like having General Custer and Sitting Bull sitting down and hammering out an agreement. That's what we're trying to do here, is come to an agreement that will work. And the key thing is what this commission decides, you guys gotta accept. That's, I think, you know, that's it, for this thing to move forward. So, that's just, and I won't be offended if you say, no, we want this kept at 5 people, or, you know, so.
I got one comment.
Yeah, Chairman, Board Campbell.
I respect your opinion on this, Dee, but I don't think with the arbitrator and the way this is set up, that the supervisors have to accept it.
They do not.
Yeah, that's true.
Yeah, I just wanna make that clear, because, you know, this is an
It
arbitration.
is, no, it's not an
Well,
arbitration.
excuse me.
An arbitration would be
Yeah.
where the final decision would be required to be
Yeah.
accepted.
Okay.
This is a working group,
Okay,
not a formal mediation, but we're hiring a experienced mediator to chair it. And
exactly, and I'm glad we got that.
Yep.
Down on record. Yeah.
I respect that.
Yeah.
too.
But I think this is all good discussion, and maybe as a way to end it up. we'll leave it up to you, two of you, to decide by Thursday if you want to add more members or not. It's up to you. I'm the minority.
I think I know my answer to that question,
Good.
if you want to hear it.
Certainly.
I think we'll leave the two citizens that I spoke of earlier. You mentioned Dean Jayden and someone that the two of us came up with separate. Leave them off. I think it's a large enough group. Respect Boyd and Gloria's comments. I also thought the same thing. But after hearing their opinions, I feel more stronger about it to keep it not as big.
Good.
That's my opinion.
I would agree with that. Yeah, it's hard to get a bigger group together too, so.
So are you back to my proposal?
Just adding
The
Wrigley
5-member group,
with Wrigley.
to add a 6-member group.
So would Dean be a member of this committee then? No,
He was a citizen.
I'm a citizen.
In my understanding, it'd be the Lombardo, John Robbins, Richard, Inver Energy Rep, White Campbell, Larry Carr, Mr. Wrigley.
Huh?
No,
no, not.
Where Carr?
I thought you mentioned that.
No, I just said, I wanted her thoughts on this.
Oh, I misunderstood then. Okay,
My proposal was 5-person group, which is,
Not
Mr. Lavarado, Todd Pritchard, Boyd Campbell, John Robbins, and a representative of Invenergy of their choosing. I don't choose that, they're a private company, they can choose who they want.
yeah,
That's my proposal for 5.
Then we added Wheatley.
Well, you did.
Well, yeah, it's on my list, yeah.
is that agreeable to the board?
Any way to move forward. I'm concerned with the cost, I want you to know that. But if that's what it takes to move this forward, I'll do it. I'll vote for it.
Discussion.
Did we get to the point where we're kind of now thinking about, we're just having a special meeting on Thursday to, get the attorney contracts and agreement letters together, and then pick a date for that first meeting?
Sounds reasonable to me.
Yep.
I agree.
Be 6 members on the commission now. Right. Yeah.
All right. I'm okay with that. Even though it costs more than I would like. But in this case, we're talking about millions of dollars of liability, potential to the county, so, let's agree to move forward. Agreed? All right. Any further questions or comments on agenda item 8? A new way forward. Any comments from the public? Anyone listening online? Anyone else in the room? Hearing none, we'll move to future agenda items. We're proposing a special meeting on Thursday, 9 o'clock.
That works for me.
All right,
Yeah, Elder Bridge plans on coming November 18th for their annual budget. I think that would be, boy, to be on board then.
all right, all right.
I have no future agenda items.
All right. Is there a motion to adjourn?
So move.
Second.
Those in favor of adjournment, say aye.
Aye.
Aye. You're adjourned.
Actually. Brother, yeah, his brother is.
He was, he wrote appeals, so on behalf of the state and the attorney general's office. Interesting paper. Sounds like.
Star Wars.
They got a lot of.
A new way forward.
Very well.
As your newspaper having
I guess they.
There you go.